Away. Thank you.
Okay. Well, good afternoon, everyone. I'm Bob Clifford. Welcome. And Clifford Law is proud to sponsor this program. I'm senior partner there here in Chicago, and we are now in our 12th year of hosting this event. It's a program intended to offer 2 hours of free professional responsibility credit, and today is no exception. That is our goal, to offer you some really quality information. We have nearly 4,000 lawyers who have logged into this program, so thank you all for attending. These folks have been registered from across the state and elsewhere, actually, what I believe to be one of the largest programs of its kind in the country. The ethics of 2020, the future is now. We are going to examine in this program issues that lawyers face in this era of technology. Our panel consists of 3 people who are very well respected in the field of ethics. I won't go fully into their backgrounds here in great detail. All of them have wonderful credentials that are spelled out in the information before you and on the website, cliffordlaw.com. But briefly, let me introduce you to this esteemed panel. We have, to my far left, we have Judge Clare Quish, who is a full-circuit judge at the Circuit Court of Cook County and sits on the bench at the 1st Municipal District in the Circuit Court of Cook County, trying jury cases. We welcome her expertise and her friendship for doing this for us today. We have Ms. Wendy Muchman, who is formerly the Chief of Litigation and Professional Education at the Attorney Registration and Disciplinary Commission, the ARDC, and she's currently a professor of law at Northwestern University School of Law. Welcome, Wendy, and thank you. And then we have Mark Palmer, who is the professional counsel for the Illinois Supreme Court Commission on Professionalism. Mr. Palmer is he's been on a previous panel here, and he's joining us again by popular demand. We encourage all of you in the room, as well as the thousands of you joining us on the web, to ask questions. We will get to as many of them as we can in the next 2 hours. We have in the room here, we have a roving microphone that will be required. If you want to ask a question, you have to raise your hand so we can get the mic to you so that everyone on the internet can also hear your question. So just raise your hand, and Ms. Foodie there will walk around and give it to you. There are materials accompanying this program that can be accessed online on the Documents tab or in the booklet that's in front of you here live in the meeting room. This seminar is also being taped for viewing later, but however, you cannot receive a CLE credit for the taped review. It only applies here live today. But the tape can be seen on my firm's website, cliffordlaw.com. And then also, to increase interactivity, we will be asking a series of polling questions with each hypothetical. You can submit your answers to those questions by using your phone, text Clifford Law, one word, and then to make it to 22333. So once again, text to Clifford Law, one word, 22333, and you can join the polling questions, and then you can text your answer to each slide that comes up. And the same instructions I just gave are on each slide, so feel free to just look at it that way. So, you know, I think I have a demonstrated history of being committed to the quality of the practice of law in our state, as well as promoting civility and goodwill among lawyers, and I hope that we accomplish that in my practice and that with my lawyers, and at this time we program also is designed to achieve that goal, and it takes another step in that direction to promote the quality of lawyering in this state. So without further ado, let me turn to the first hypothetical, and it's on page 1, even though I'm looking at a page that's not numbered. Struggling with styles. A.B. Law represented Fashion, TJ Fashion, in a lawsuit for tortious interference with contractual relations against needless markup. I tell my wife, needless markup, Neiman Marcus. Okay, needless markup. All right, after extensive pretrial discovery and a jury trial, TJ receives a $75,000 award of damages. So, first question, who is AB's law client? Is it AB Law's client? Who's their client? Is it TJ Fashion? Is it the CEO of TJ Fashion? Does it matter? And I'll interject a question that a gentleman asked me before the beginning of the program. We didn't identify here if TJ Fashion was an LLP, a PC, an Inc. Does all that matter? Wendy Muchman, I'll give you the first shot at the answer here.
Okay, so looks like we're 100% right. And the idea is in any single issue of representation or consideration of ethical issues in a problem, the first thing you have to figure out is who's your client, right? It's easy when you're doing a divorce. If you're representing Jane in the divorce, Jane is your client. When you're representing an entity, Rule 113, which is your guiding rule on entity representation, says the entity is your client. So you have to figure out who speaks for the entity. So the CEO might speak for the entity, and that might be the person with whom you have the confidentiality and privilege, but still, your client is the entity. That's the default position. And what we would see on occasion at the ARDC is that lawyers get themselves in trouble by not stopping to figure out who they represent at the onset of an engagement, right? So an idea guy and money guy come to you about representation, and lawyer decides, okay, well, I'm going to represent you in setting up a new entity, but then money guy gets sick of idea guy because he's dragging his feet, and lawyer's been writing letters saying, we represent idea guy and money guy instead of entity to be formed, and never tells idea guy, sorry, we're not your lawyer, so all this information you gave us about your ideas, we're not going to keep it confidential, right? And we see where that ended up in a bad situation for the lawyer that failed to say, no, don't represent idea guy, don't represent money guy, represent entity.
Thank you. And Mark, do you have anything to add to that?
Well, turning right to the rule itself, 1.13 right there specifically talks about the organization as a client. So that's very important to draw your attention to. But sometimes I think the strong takeaway is that, like all lawyers, we like to have, how do we analyze the situation? And if you're analyzing the situation on, is there a client-attorney relationship or not, or who is it between, do you look at it from your viewpoint, the lawyer's, or the client's viewpoint? Which is more important? Which holds more weight in the analysis? And clearly, the case law and ARDC would agree the client's perspective is what's important. That's where you should focus your energies on. It's not necessarily how much time was spent or how much money was spent or is there a formal contract between you two. Yes, those are important, but the gravitas of the evaluation is what does the client think is going on here? Does the client reasonably believe that you are his or her attorney?
And I suppose, by the way, just to pause here, at the in the booklets that you have and online as well, at the end of the booklets, you can find all of the references. So you'll see the reference to the site that Mark just gave, 1.13. But so going back, well, why does this really matter? I mean, who decides settlement? How does a lawyer rightfully go about an analysis of conflicts? Wendy?
Do you want to do the poll question, or?
Do we have a poll question yet? We do. Well, let's have a poll question. Use the mic.
So why do we care who is the client?
Yeah. Okay. So the poll question is, client decides the settlement, analysis of the conflicts, both or neither. Poll question is both, 167%. Analysis of conflicts and...
This will go for about 30 seconds, and then we'll cut off after 30
seconds. So I think overwhelmingly, we're past the 80 percentile into the 90 percentile on that both matter. The client decides the settlement and analysis of conflicts also matters. So that was a softball. We started with a softball here. We'll get harder as the afternoon goes on. Okay, next hypothetical. Struggling with styles continued. After the jury trial, AB Law withdrew from representation of TJ in the tort case and actually sued TJ for unpaid legal fees. TJ countersued AB Law for legal malpractice. TJ alleged in its malpractice suit that the partners at AB Law had breached their duty of loyalty to TJ by agreeing to represent needless markup and in a contract matter against TJ while the TJ and versus NM lawsuit was pending. So here we go again. Can AB Law represent NM since they withdrew from representation of TJ after the jury trial? So here we go. Yes, no, Wendy, Mark?
So the next thing you have to figure out, and it looks like a lot of you are on the completely right track, is in a conflict situation is, are you looking at a former client or are you looking at a current client? And as Mark said, an important point in the analysis is reasonable belief in the mind of the client. So let's just say you withdrew, you're saying it's a former client. All former client cases are consentable or possibly consentable. Some experts say it's never a good idea to sue your former client, but really the analysis under the rules is it the same or substantially related, which a lot of you got, and if the answer to either one of those questions is yes, so it is the same or it is substantially related, the next part of your analysis focuses on, did you acquire information in the course of representing the client that could be used in the first matter, that could be used against the client in the second matter. And as most of you might remember, the test isn't what you actually learned, it's whether or not you could have learned that information. Would you normally have learned that information in the course of representation? Because obviously you shouldn't be using confidential information against a former client.
Yeah, and I would just add that in evaluating, again, are you the attorney? Have you accepted the relationship? Just like they have the right to fire you, you have the right to fire them with limitations, and we'll talk more about that, of course. But what have you done to initiate the relationship? And that does not necessarily need to be a formal act. That can be your actions, right? We're going into contract law here. Your implied actions as a lawyer to fulfill their needs, their legal services, ties you into that attorney-client relationship. So that's important to remember. That's just a point I wanted to figure out. Or the opposite, if you don't disavow your representation of them, you're hooked too.
Which no one ever wants to do, right? Law firms don't want to write the letter saying, thank you so much for representing you in this matter. It's concluded. If you ever need our services again, call us. So then you have to figure out, is it always easy to know when a client is a former client? Sometimes it's not. So what if you send advertising material? What if you have promotional brochures on the law? You're an employment law firm. You send all your clients information on updates on the law. Does that prolong the attorney-client relationship? Those are questions, as Mark pointed out, that you have to be asking yourself.
You know, when I read this one, it struck me, I don't know why, but because neither of you made reference to it. Is there anything here about the appearance of impropriety that you're taking on a case?
I agree, Bob. I feel like that's why a lot of experts say it's a bad idea to sue a former client, especially when the time period is so close in time, right? If it's 10 years later and you're suing a former client, or I took 10 years arbitrarily, but if there's some distance between the representations, maybe it's a different question. But here, literally, you just withdrew from the representation and now you're suing them. That's not a good idea.
Seems a bit off. There we go.
Agree.
Okay. I saw a gentleman with his hand up there. Yes, sir.
Yeah, getting back to the first issue, is there any reason why you couldn't represent both the CEO and the corporation if everybody agreed?
Not if everyone agreed, right? But you'd have to do a conflict analysis, and then in what capacity are you representing the CEO? That's always the risk for lawyers doing entity representation. Are you representing the CEO in his capacity as CEO of the organization, or are you representing him personally? It's a little riskier, right?
But you know, something that's going on right now a lot is that, okay, the CEO is discharged or leaves the company.
Right.
And then all of a sudden there's litigation going on and the plaintiff lawyers say, we want the CEO's death. And the next thing we know, the lawyer for the corporation says, we're going to represent him or her. And it just smells. So what's the remedy for the plaintiff lawyer litigant? To go in and make a motion to disqualify? What comes to mind, Wendy?
Bob, so many times we faced that issue at the ARDC where we had a respondent and then we had to depose other people from the law firm, and the respondent's lawyer represented everyone from the law firm, and we never figured out what the remedy is, frankly, because it's not our conflict to raise, right? And they'll just say, oh, there's a waiver and it's none of your business. It's attorney-client privilege, right? But it clearly looks bad, and when the case gets to trial, it certainly looks like there's an effort to consolidate or circle the wagons, let's put it that way.
Well, that's where cross-examination comes in.
Exactly.
See where, okay, you start saying, doesn't this smell a little bit? All right. Anyway, all right, next one. Moving on. Limited scope representation in Illinois state courts. The client hires attorney A to represent him as the defendant in a residential eviction action. The client cannot afford to pay attorney's full fee. Attorney agrees to represent client for only portions of the defense of the case for a smaller fee, but not for the pretrial conference or trial. Attorney and client orally agree to this arrangement. The attorney files a general appearance on behalf of the client, but at the first court hearing tells the court and opposing counsel that he will only represent client at status hearings and in settlement negotiations. The case does not settle. The client appears on the trial date, but the attorney does not. What should the attorney have done? Put the full force limited scope representation agreement with the client in writing, file a notice of limited scope appearance with the court, not a general appearance, all the above, none of the above. Judge Clare, what do you think about this?
So it looks like we got 100%, 90% accurate with all of the above. So limited scope appearances have been around since 2013, but they haven't really been in wide use until more recently. They implicate two specific rules. One is Illinois Supreme Court Rule 13C6, and then the other one would be the Illinois Rule of Professional Conduct 1.2. So this is technically called, or people informally call it, unbundling. So the lawyer is responsible for some portions of the litigation, and the client's responsible for other portions of it. Typically, this is used, I've seen it a lot in landlord-tenant cases, eviction cases, family law cases, and it's supposed to benefit everybody. It's supposed to have a more fair, efficient, cost-effective relationship. Benefits the litigant because they can have some representation. They're not fully self-represented, and they can pick and choose tasks within their budget to have the attorney do. Benefits the attorney to only be paid for and have to do certain tasks. It also benefits the court system and the judges because there's more efficiency when there's attorneys involved and there's some counsel for self-represented litigants. The main points of this rule, it's only for use in civil cases. You have to enter into a written agreement with the client to provide for the limited scope representation. The attorney also must file a specific notice of limited scope appearance with the court. The Illinois Supreme Court has created a form that's been approved by the court, and it's to be used in every county throughout the state. And that is on the Illinois Supreme Court's website. Under the rule, it gives you literally a check, fill in the box. You explain exactly who the party is, what you're going to do, exactly what tasks the attorney will do, and what the client will do. And then also what's very helpful is the client has to sign it. So that also should help with informed consent, so the lawyer and the client are on the same page. You cannot make an oral request in court to file a limited scope appearance. There's a Supreme Court case from last year, People versus Gawlak, G-A-W-L-A-K. It sounds like a criminal case. This portion of it was a civil portion of a criminal case. And the lawyer tried to do it orally, and the Supreme Court clearly said, no, you can't do it orally, and set forth exactly what you need to do. Once the representation is finished, the attorney must withdraw. The rule and the comments say that they would prefer the lawyer to withdraw orally at a court hearing, but only if the client's present, and then everybody's on the same page as to the attorney withdrawing. Otherwise, the attorney has to file a notice of withdrawal, and again, that's set forth in Rule 13 in the appendix as well. If the client objects by saying, my attorney didn't finish the representation and didn't do what he's supposed to do, the judge will hold an evidentiary hearing and then make a determination as to whether the attorney did what they did or didn't do.
Please enter the following MCLE verification code, 4529.
A lot of times lawyers don't tell anyone that they filed a notice of limited scope appearance, and then they just suddenly don't show up at trial. And so the opposing counsel is wondering what's happening, so am I, and so is the client. So best practice, and we do have e-filing now in Cook County, but we are nowhere near the federal court level. I don't get filings. We don't see any of these documents ahead of time. So I think the best practice for attorneys is if you have this notice of limited scope, bring it to court, the first court appearance, give a copy to the judge, tell opposing counsel, tell everyone what's going on, and then everybody can be on the same page. I have seen, and I know lawyers have complained that judges, the lawyer shows up and says, well, I'm not doing this part of the trial. And the judge says, oh, no, yes, you are. I'm not letting you out. There's confusion there, and part of it is if the judges aren't aware of how the rule works, or if the judges aren't aware that you have a limited scope or what it's for. So I think the best way to do it is to tell everyone right at the beginning and give the judge a copy of it. And the committee comments specifically say judges need to let the lawyers withdraw when they've completed their representation, because it would disserve the interests of justice by discouraging attorneys from taking such limited scope representation. So I think best practice is tell everyone what's going on.
Judge, once again, what were the areas of practice where you really have seen this happening?
A lot of times in family law cases, in eviction cases, landlord-tenant cases. And I will, there's a resource, and we talked to Mark about this ahead of time. In the Supreme Court website, they have a whole section on the right-hand side for access to justice. And it has a bench card that specifically lays out all the requirements. And it has a lot of other different resources for lawyers and self-represented litigants alike. And the Chicago Bar Foundation also has a limited scope representation toolkit, they call it, on their website, that includes checklists, discussion points with clients to help you figure out with the client what the best way to handle it would be.
Mark, anything to add to that?
Yeah, definitely check out that toolkit. It's about a 17-page PDF with embedded links to everything you need to know. It's put out by multi-agency, including the Supreme Court, the Chicago Bar Foundation, et cetera. But yes, this is an access to justice issue, but I don't mean that purely as a pro bono issue. I mean that as a money-making issue. And there's a lot of solos and small firms listening to this program. This is a way to open the door to new clients, period. This is a way to make more business. If you are a lawyer and you can say, I have a menu of services to offer, and you can pick and choose how you, the client, want to engage me, and now I have the rules that allow me to do it, here's your opportunity. Yes, it's going to take some legwork to create the forms, formalize the contracts, prep the pleadings. The Supreme Court's given you half the forms already. They're already there. But there's segments of types of cases that I think this really applies to that you can really engage more clients. You can open the door to people who otherwise, the first thing they're going to see is just your billable hour. Boom, they're turned off, and they're going to try to be a self-represented litigant. And the courts don't want that. You don't want that. You want to make some money. The court wants to have you helping them, even if it's limited. It should be win-win. So I hope, this is only 6-7 years old now, but I hope it gains popularity for those reasons.
Yeah, we have one question in the audience. Or a couple. I would say I would not advocate the use of this in tort litigation. I mean, can you see it now? We file an appearance on behalf of a plaintiff, and we go to a judge, and we say, by the way, we're here to see if we can settle the case, but if it's got to go to trial, I'm out of here. You can't have that. Okay? Yes, sir.
My question is to anyone on the panel. Do you guys know if this is the same rule in other states as well? I'm really intrigued by this. I'm in the risk management business. I'm a claims adjuster. I adjust professional liability claims. I didn't know about this rule in Illinois, and I think it has implications for your malpractice carrier, because I've never seen a claim like this where the lawyer says, well, I just filed a limited scope appearance.
Well, that's a good thing, right? That you've never seen a claim.
Yeah. Is it? Can you give us an idea? Do you know? Is it applicable in other states?
Yes.
Thanks.
So about 6-7 years ago, when this started gaining traction, Illinois was not the first state to adopt the model. We adopted it from some other jurisdictions, and at one point, I want to say, I feel like there's at least somewhere in my mind, and this could be crazy, but Mark and Claire will correct me if I'm wrong. I want to say it's somewhere between 13 and 26 other states have some variety of the limited scope rule.
Yeah.
And the idea, again, as both my co-panelists have mentioned, is access to justice. So you always have to provide competent representation, but the idea, Mark said it eloquently, was give your client a choice, except, as Bob said, don't say, ha-ha, if you have to go to trial, I'm out of here.
Next question. Yes, sir.
Related to that last question, on my renewal application for malpractice insurance, there was a question, do you ever engage in limited scope representation? So that is being asked by some insurers. My question is, as to ghostwriting briefs for pro se clients, I don't think that requires any sort of appearance, but I think there's a difference between Illinois law and the federal court's approach to ghostwriting.
Press the on button. It might not be on.
Is there a difference between the Illinois courts and the federal courts' attitude towards ghostwriting briefs for pro se clients?
Well,
Any panelist?
what I know of it, Rule 137E, Edward, I think addresses that specifically, allows it. The attorney does not need to sign. In fact, the rule actually says, if I recall, it says in the rule the self-represented litigant should sign their pleadings, but the attorney can help the person. So that can be as small as a situation where you have a courthouse steps help desk that's manned by a lawyer, or you actually have someone engaging you on a limited scope, but they're carrying the oar from there.
Yeah.
And that was a big discussion when the rule was adopted, was should ghostwriting pleadings be allowed under the state court rules? And they made a conscious decision to say, yes, it should. And I don't know. I'm thinking the federal court rules would specifically provide or not, and I'm guessing it might be the latter, but I'm not positive.
Yeah, they probably would provide, I would think. Well, that was a good one. Well, thank you.
So the rules you really need to pay attention to, and Judge Clare mentioned a couple already. So you got Rule 11, which is tricky because, again, that's the service rule, right? Rule 11 has all those crazy things now that we have electronic service requirements. But if you're helping someone limited scope, you have to serve both the lawyer and the self-represented litigant. That's a tricky one to remember. So if you want to dive in that area and know that part of Rule 11, it's Rule 11F Frank.
Yeah,
So you got Rule 11, 13, 137, and then you also have the professionalism, rules of professional conduct that apply, like 1.2.
Okay. And then in our polling data, 96% of the people agree with everything they just said. So there you go. All right, so playing with metadata. Now, before we talk about this one, I just want to make an announcement. From a practitioner's perspective at the moment about what's going on in serious litigation, we all need to learn about ESI, electronically stored information. We need to learn about technology-assisted review. You're going to hear it called CAR. We need to learn about CAL, which is the continuous active learning. Lead follower, get out of the way because that's where litigation is going if it's a document-intensive case, and this one will prove it in terms of the metadata. So in 2019, Len Lawyer is the subject of an ARDC investigation for failing to file carry client's case within the statute of limitation. The lawyer's response to the ARDC includes a copy of a letter to the client dated June 2015, which is before the statute of limitations expired on the client's case. That letter advised the client that the lawyer will not take the case and that the client better find another lawyer before the statute expires. The lawyer tells the ARDC that he did not engage in misconduct since the June 2015 letter to the client was sent before the statute expired, and timely advised her that his office would not file her lawsuit. During the ARDC's investigation, though, through the metadata, metadata is the excess data that's out there. It's the exhaust in emails and the like. He discovers that the June 2015 letter to the client, ARDC counsel learns that the letter is a fake, and it was actually sent in 2019 at the time the lawyer responded to the ARDC. I think a lot of the truths or false are obvious here. The lawyer, is the lawyer's isolated neglect, would it be subject to discipline? And because the lawyer lied to the ARDC, should he also be subject to discipline? Wendy and Mark?
We can't trick anyone with this one. So Isolated neglect might be a malpractice case, but it is not a discipline case. Because you lie to the ARDC, you are subject to discipline. It's a violation of a separate rule. It's 8.1b, and the facts of this problem are actually taken from a case where an Illinois lawyer was disciplined. And lying to the ARDC holds a pretty serious bottom line, and I would say as a typical matter without mitigation, if you tell a lie in your response to the ARDC, the low-level sanction is 6 months. So the cover-up is always worse than the crime.
And you know, as a best practice, two things. The first is that plaintiff lawyers make the mistake of signing up a case, and they put it in the drawer, and it goes to sleep, and they do not get a lawsuit on file in a timely fashion. And a lot of times what happens is they miss the statute, they miss a defendant. I'm sure Donna Sokol is here, does a lot of med-mal defense work. I'm sure over the years you've seen where plaintiff lawyers file a case on the eve of the statute of limitations. They get one or two of the defendants right, but there are a couple that they miss, and it becomes a real problem for the client, even though the lawyer was hired within 2 months of the original event. And it's just such bad practice. And a related issue that goes along with that for the client is what's embedded in this question is I'd like to know, let's assume the lawyer in fact did tell the client in June of 2015. How long did the lawyer have the case, and when did that statute expire? Because one of the, again, terrible things that happens to clients in these cases, the statute, let's say, expires on July 7th, okay, and the lawyer tells the client in June. It's really super hard in a tort case atmosphere for a client to hire another lawyer, and so you're effectively dooming the case and sending the wrong message to the client. So I think here, of course, again, our polling people are right this time at the 97% level. Okay, so here we go. Judges, lawyers as social media friends. This is right up there every day. This one's a new one. One of the partners at Warren, Brennan and Associates was recently appointed to the bench. She has deep ties to the community for her professionalism and personal contributions. She's authored some past blog posts and built up her social media presence over the past month. She is no influencer, but she has several hundred friends and followers. Now, upon taking the bench, she is faced with the decision to deactivate all social media at the risk of impropriety or perception of impropriety, or keeping her social media friends in place. So select the best response. She's required to remove any friendships, followers with any attorneys, putting at risk her integrity, impartiality, or appearance of impropriety. She's required to remove her social media presence. It is a per se violation of judicial canons. C, she could remain on social media and continue to practice avoidance of impropriety and ex parte communications. Or D, she would use her judicial position to further engage in social media to become a justice influencer, to empower the rule of law and access law. That's a good one, though, justice influencer. I like that. Mark, we're going to give the tough one to Claire, but Mark, how about you start?
Mark, go first.
I'll go first, but Judge Clare has a great recent real example to follow up on. This is very real life, right? And we see this
It's not based on me, though. Before the real life example gets me slightly worried. Sorry, Mark.
Very much. And look at this is probably the hardest question we've had so far. We don't have a bright line answer, and this isn't a bright line answer kind of question, frankly. But we do have a lot of guidance from opinions across the country, including in Illinois. And I just want to touch on a few things that those opinions say from bar associations, some binding, some not. The general categories those two fall in is one, yes, it's allowed, but of course use caution. Or two, nope, you can't do it, per se violation, which is one of the options up there. Use your best judgment. Do the rules that we currently have in place apply to this situation? Is there actual impropriety or perception of impropriety? What is social media? It's a new environment that's only been around, 20 years maybe now, but hasn't really changed. The definition of a friend is a different, is Judge and I being friends on Facebook different than me going out and having lunch with her every day for a lunch group? Yes, different context matters. So what does the rules say? The answer currently, at least in Illinois, but some states are different, is You do not per se have to disqualify yourself, turn off all the lights, and leave the platforms. You don't have to do it. Should you? Probably. Can you? Absolutely. But you always, no matter what, have to take the judicial canons in consideration as a judge and the rules of professional conduct as a lawyer, right? Those are the must-dos. I just want to point out one state, which is Florida, which has been very interested. Of course, Florida's interesting about everything, right? About 10 years ago, 2009, Florida put out their official opinion from the Florida bar saying, per se violation, you cannot do it as a judge, can't be friends, end of story, done. A little bit of time passed. 2012, there was actually a Florida case in the appellate court where the appellate court kind of affirmed that opinion by saying, yes, that's right. And in this case, it was a criminal case. A new trial was awarded because the judge and the prosecutor were Facebook friends. That's the simple version of the story. And they said that enough, that alone was a perception of impropriety, even though there was no discussion of the case online or they weren't posting about the case. Not yet, that's other cases. But the perception alone was enough for the public to say, that's not fair, there's a possibility of impropriety, new trial. That's 2012. Fast forward to 2018, now we're up to the Florida Supreme Court, and they say, maybe it's okay. And they say just the opposite. It is no longer a per se violation. And why do I point out this timeline? Because technology evolves, because society's understanding of technology evolves. And I think this is a perfect example of what we see. 10 years ago, 15 years ago, the understanding of what two people were friends on Facebook or followers on Twitter or whatever, MySpace back then, right? That's changed. It's evolved. It understands. And it's all about the context. Different in Cook County may be different than down in Champaign County or Bloomington Normal. It's all about context as well.
Judge Quish?
So the ABA has a formal opinion from 2013 saying that the judge may participate in electronic social media, but also the judge obviously must comply with the relevant provisions of the Code of Judicial Conduct. So in Illinois, that's Rule 61, which is the judge must uphold the integrity and independence of the judiciary. Rule 62, you have to avoid the impropriety and the appearance of impropriety. And then Rule 63.7, the judge should abstain from public comment about pending or impending proceedings in any court. Essentially, the ABA says context is key. Look at the context of the actual relationship that the judge may have with the social media. But the case that Mark's talking about, there's a case out of Wisconsin from a year ago today, actually, February 20th, 2019. Miller versus Carroll, 925 Northwest 2nd, 580. So in that case, it's a contentious child custody case and between two parents, mom and dad. The judge hears an evidentiary hearing at which both mom and dad testify. The judge takes the hearing under advisement. In the next couple of days, the mom sends a friend request to the judge on Facebook. Judge accepts it.
Ooh. Ooh,
the mom likes several of the mom likes several of the judge's posts. The judge says he saw her posts but didn't actually like any of the posts. Then they come back for the ruling, and the judge rules in favor of the mom and gives her full custody of the child. No one disclosed the Facebook relationship. After the hearing, the dad figures out this Facebook friendship, brings it up to the judge, and files a motion to reconsider, and the trial judge denies it, saying, yes, maybe I saw some posts on her page. Yes, maybe those posts involved domestic violence, which is part of the issue involved in the custody case, but I already decided how I was going to rule before, and it didn't affect me. The appellate court reversed. They said, we're not creating a bright line rule preventing judges from using social media, but in this case, the judge's undisclosed social media connection with a current litigant created a great risk of actual bias, resulting in the appearance of impropriety. And they focused specifically on the timing of it, the fact that the judge heard the hearing, then accepted the mom's friend request, and then ruled and didn't disclose it. The court cautioned that judges should recognize that online interactions, like real-world interactions, must be treated with a degree of care. Now, this involves a child in a custody case, so now it's going back for a hearing before a different judge. But then the Wisconsin Supreme Court granted the petition for leave to appeal. So they granted that in August, and it's still pending. So it'll be interesting to see how the Wisconsin Supreme Court comes down in terms of this analysis.
Yeah, sure.
So just to make sure
Were
everyone...
you done, Claire?
Yes.
Yeah, okay, I'm sorry. Go ahead, Wendy. Yeah.
So can't top that case. That's a great case. But I just want to make sure that everyone understands when we say what an ethics opinion is, because we all use them every day. They're not law, they're guidance. So you can get them from the American Bar Association, the Illinois State Bar Association, the Chicago Bar Association, and then other states also, their bar associations issue ethics opinion that take the facts and then analyze them under the rules, and they're excellent guidance that can help you solve problems, but they're not law per se. The rules are the law.
You know, what came to mind for me when Judge Quish was saying, telling us her remarks, as a practitioner, and we deal with hundreds of clients, our instruction to clients has changed nowadays. You know, we do tell clients, stay off of social media during, you know, as it relates to the case. I don't know that we've ever said, you know, don't give the judge a friend request, because that would seem obvious, but I guess now we should. Sonia, add that to the list of what we tell the lawyers in our next lawyer meeting. But, you know, it's sort of like years ago, we were walking into the Daily Center, and I happened to say to a client, by the way, I said in jest, I said, you know, I hope you left all your guns and knives behind. He said, well, can we talk about this for a minute? So, you know, you gotta do these things. All right, moving on, number 5. Warren Brennan Associates recently updated its website and started writing a legal blog, BLAWG. And they were in order to blog. Okay, got it. All right, in order to bring the firm's goodwill and reputation into the 21st century. The managing partner assigned the project to a couple of junior associates who, fortunately, these savvy new lawyers were quick to spot the ethics of what was involved in the process, so they have a lot of concerns. First, they knew more website traffic would be generated if the firm published a weekly law-related blog addressing legal issues served by the firm. And then a senior associate had been arguing an appeal for a pro bono criminal client. This might highlight the firm's diverse abilities and commitment to providing pro bono representation. Perfect, right? Yeah, it seems so. Well, let's select the response. So long as you have the client's consent to blog about the case, you're protected. Or the client's consent is good but not required, as it falls under the trial publicity exception to confidentiality. Or consent or not, this is a pending matter and is off limits. Or you need to wait until all appeals are final and only non-confidential information is used. Our polling folks are saying that, well, at least only half. We got a lot of controversy going on here. Mark, what's your take on this?
Yeah, this is not an easy one. Again, and you can argue with the bright line rule, and now it starts to get down to maybe a little bit of trial strategy. Depends on the case matter and such. But really, the rule, always go to the rules first, right? Just like any case, go to the statutes first, identify the rules. Just like Iraq back in law school. You got the issue of the rules. In this case, rule number 1 is always going to be client confidentiality in this issue, 1.6. That's important. But if you don't know this already, there is a trial publicity rule. 3.6 allows you to talk about things. Doesn't mean you have to, but you can. But again, you're going to have that conversation with your client. There's also some other factors to always think about. Is your blog advertising or not? Are you having a one-way or two-way conversation with the quote-unquote audience? Those are factors. So if you're taking notes, as you should be, some tips to write down. If I have a blog, I better well have some disclaimers on that blog. You know, the classic, this is not attorney-client or attorney-client relationship formation and such, but also things like past results do not guarantee a similar results for others. That kind of thing is great, I think, as a disclaimer. And of course, always the recommendation that you should contact an attorney for further advice for your case. Always throw that out there. 1, they should. 2, it emphasizes that this is not an attorney relationship we're creating right here. Go make your own somewhere else. But as far as the marketability of blogging, you see more and more lawyers doing it. It has great value. It has context, but you got to do it right. You can't just sit down and write a few lines and hit return and get it posted. You got to take planning and talk to some people who have some experience blogging to know how to do it right. Consistency is key and so forth. And lastly, I'll say there's some great blog aggregates out there. The ISBA helps you get your blog disseminated out into the world on a national level. LexBlog is a national, and they do it all for free. So it helps you out, and even the solo practitioner can use marketability of blogging to benefit yourself, but do it right. Of course, do it ethically, with confidentiality being the first thing to look at.
Yeah, Wendy?
I would say confidentiality is the biggest thing to look at, and then the advertising rules, which basically the summary of the advertising rules, which are 7.1 to 7.3 are, don't make any misrepresentations, right? But that said, if you are going to blog about a particular client's consent, a particular client's case, the number one thing you have to do is have informed consent before you do that. And an aside, there was an Illinois lawyer who decided as a matter of trial strategy to post a video clip that he had received in discovery from some prosecutors. And the video clip, he posted under the video clip on YouTube, "Here are the cops planting drugs on my client," without the client's informed consent. Problem was, when you watched the video clip, you could tell that it wasn't entrapment. No one planted drugs on the client. The client sold drugs to an undercover police officer. Clients from a small town in southern Illinois. Now all of a sudden, her information's all over YouTube and everyone knows about it, right? So that wasn't a blog, that was a lawyer trying to use it as trial strategy, but it's a perfect example of how, and that was his defense was, no, this was my trial strategy, it's a means of representation, I don't need client consent. Wrong. Under the 1.6, confidential information is all information relating to the representation. It's really broad unless it's permitted or required by an exception or you have informed consent of the client. So think informed consent of the client before you put your client's name out there in any way.
You know, two things come to mind. One on to Mark's comments. So the blog site you're talking about in terms of advice is an ISBA site, is that right?
They can, if you submit your blog to them, they can
Yeah.
help you publish it
Yeah.
across.
And I'm using this as a intro to a you know, personal privilege thing. All bar associations right now are struggling, whether it's the CBA, ABA, ISBA, in terms of membership, because folks are not appreciating or understand the value of membership. There's one right there, why young lawyers in particular ought to be members of the organized bar as one of the benefits that comes from being that. And on a totally different, but kind of related to me, in the tort litigation space, we see lawyers out there advertising results, and they're just not accurate. And yet, you know, I bemoan the fact that there are no lawyer police, because it's just tough. Nobody's doing anything about this. Does the ARDC or the ISBA have any, like, you know, hotline where anonymously you can, you see something bad going on, you can report it, and maybe they do something about it?
So the ISBA has an ethics line that you can call and get guidance from a lawyer. It might be advice on the ISBA hotline.
Right.
The ARDC has the ethics inquiry line, which if you call their main number during working hours, Monday through Friday, a staff lawyer will give you guidance, not advice. The ARDC, under the rules, can't give you advice. They can give you guidance. It is confidential. It can be used neither in your defense in any subsequent disciplinary proceeding, nor can it be used against you, nor is it ever used, ever, I say ever used, to docket on an investigation against an Illinois lawyer.
Right.
And I answered those calls for many, many years myself, and no, those calls are confidential. We keep no records. You don't have to tell us your name. The only record we keep is the nature of the inquiry, like what was the rule violation of concern, and we do that more for our own purposes.
Yeah, well, thank you. That's terrific. That's terrific. Perfect. All right, we had a question in the audience, and while the mic's being handed, let me announce that the rolling poll, 2/3 of you thought that you had to wait until everything was final in the before the non-confidential information.
It's a good,
could be
safe
used.
answer.
Yeah, that's a
Good
That
safe
actually
answer.
makes
Safest
me
answer.
happy.
There you go. Yes, sir.
I'm getting bombarded by emails.
How could you use the mic? Because that's the only way
Yeah,
people
I'm
hear.
getting bombarded by emails that we have a client for you, we want to refer a client to you. And I said, I can't take referrals, I don't even know who you are. But I keep
Yeah,
getting
that's
them.
spam. That's spam. There's some, they don't erase those. They're spam. We get them, I think we all get them every day. You know, have a client for you, I need representation on on a matter out of Hong Kong. Will you represent me?
Super dangerous,
Yeah.
delete them, don't even open them.
Exactly. Okay. Time for one more question, then we'll go on. Mr. Hugh Griffin, Appellate Counsel Extraordinaire.
So my question is, how do you relay 1.6 with the 3.6? Because, you know, I'll have a case and the law bulletin will call me, and ever since 1.6 came out, I pretty much say, look, I can't even talk to you about it until I call the client and see if they'll let me do it.
So 3.6 has specific safe harbors for you as a lawyer, and I'm going to say in my thoughts, 3.6 is more related to criminal litigation, and it has certain safe harbors. It allows you to talk about the claim, the offense, the defense. If it's a criminal case, you can talk about, for example, danger of the person involved, and you can technically give information of public record. But I think even in civil cases, and some might disagree with me, but in 1.6 does not say just because something's in the public record,
No, I
it's
know,
not
yeah.
confidential. Obviously, you know that. I could tell you know that. So I think that if you want to comment about something in the public record, it should be a conversation you have with the client.
Okay.
Just one other thing I want to add from the audience here on the internet, and Mark Palmer, you would know this as an ISBA Board of Governors, that ISBA Mutual will also talk to their insureds and will give them access to mutual counsel with questions and concerns regarding these issues, is what I'm told.
Okay. Well, I think all the insurers will do that, right? I mean, the gentleman over there, if I call my insurer and say, hey, can you bring somebody in to give us a lecture on topics A, B, and C, you'll do that, right?
Hotlines are pretty standard in the industry these days.
Hotlines are standard in the industry. Okay, moving on. Number 6, discerning fact-based discovery. Lawyer received discovery request in a federal court matter for, quote, all notes related to the case, end quote. While researching the relevant documents, lawyer experiments with data range and search terms. Lawyer's search resulted in added words or phrases to documents that were produced to opposing counsel. When documents were produced in discovery, nothing reflected that the documents were altered during the lawyer's experiments with the e-discovery system's search capacities. Opposing counsel files a motion for sanctions, arguing that the lawyer altered the documents to boost lawyer's client's defense of the case. The lawyer claims the documents were not intentionally altered and that lawyer and opposing counsel had a conversation about the issue. Opposing counsel denies any such conversation occurred. Is the lawyer subject to sanctions, yes or no? Let me start with Wendy.
The lawyer is subject to sanctions. This is based on an actual case from Texas, from 2019, Merge Office Interiors versus Alpha, ALFA Adhesives. And the lawyer actually claimed in court later that he was experimenting with their e-discovery platform and he didn't understand how it worked, so he had altered some documents and accidentally produced them. And the court said no. And that's a competence issue, right? We all know that also the competency rule was amended to include the requirement of technological competence some years ago. And there's another Texas case actually where a lawyer was disciplined for failing to discern that a client had given him some discovery that was fake. So I think in Texas they seem to call it fake discovery or fake-based discovery. Here, I would say that if you look at cases for it, it's more often referred to as spoliation of discovery documents. And there is a burden on you, the lawyer, to understand what it is you have and what it is you're producing. Bob just talked about it.
Yeah, and I'll say something again after Judge speaks to this. Have you seen this yet, Judge?
I have not seen this in my courtroom, luckily. But in the Texas case that Wendy's talking about, the client, they actually called the client in, the judge did, and had an evidentiary hearing about what the client did in terms of the searches, and the judge didn't believe him and was going to refer him to the U.S. Attorney's Office for perjury. So the client in that case gets in trouble as well as possibly the lawyer. So that's
right.
And luckily I have not seen this in my room.
And this is what I was referring to earlier, that I think it would behoove all of us, well, if you're involved in litigation of any kind, to take some further continuing education programs on this e-discovery stuff, Actually, I spoke to Dean Rosada today about it. I think that Paul might be offering a special program in the future about it with some nationally known experts we're going to bring in, so stay tuned on that one. But it is very, very important that you understand this. And it used to be that the bar thought, well, this only applies to the big firms. This is a big law issue. That, you know, this is Jenner's problem, Winston's problem, whatever. It is not. This is starting to hit the rubber meets the road on even the small kind of cases. What if you're involved in just a routine corporate dispute between a couple of small, closely held corporations, and all of a sudden you got altered documents that are being given to you, and what are you going to do with them? You've got to be able to understand that stuff. Okay, and our jury thought, our electronic jury thought that the lawyer was 82% likely to get sanctioned. How about that one? Okay, moving on. Pam tells me I have to move it along. She says I talk too much. Okay. The other day I had a judge tell me I tell too many stories. I said, well, let me tell you a story about that. So, all right, the deep fake. Carrie client has hired you to get her divorced from her husband. Carrie and her husband, Sam, currently have joint custody of their minor son. While the divorce is pending, she brings you some videos of security footage that she tells you are from her former husband's apartment building, and appear to show her husband in the lobby of the building buying illegal drugs and soliciting a prostitute while their minor son is standing next to him. Carrie tells you that she has a friend who got her the video and will testify to its authenticity. You call the friend, Victor, whose business is called Video Verify. Victor tells you that the video is authentic. You file a petition to modify custody. Sam's lawyer responds denying the allegation and stating that the video is a fake. Continued. You talk to Carrie. She assures you that the video is real and that Victor from Video Verify will testify the same. Based upon your conversations with Carrie and Victor, you decide to proceed to hearing. You have some nagging doubts, but your client and her friend tell you the video is authentic. Right before the hearing, you find a court opinion where sanctions were imposed against the party who used Victor from Video Verify as an expert. The opinion refers to Victor as a fraud. You decide it is only one case, and you proceed. Only one time. Come on. Everybody's entitled to one free bite. Come on. All right. At the hearing, you call Victor to testify and authenticate the video. In rebuttal, your opposing counsel calls an expert witness who testifies that the video was fake using a deep fake software. Your opponent seeks sanctions against you and client Carrie. What should you have done differently? Not used the video, sought a continuance to additionally investigate, C, not believed your client, or D, nothing, it wasn't your fault. Wow. Wendy, is this from a real case?
Yes.
Yes.
And what is a deep fake video? It actually is the result of AI or machine learning, and it is an app that can merge, combine, or superimpose video clips into a fake video and make it look real, right? So what do? The concern is the burden's on you to do the investigation before you call that expert to testify, right? And the interesting thought is that if you are violating discovery by producing a document that is false or destroyed or somehow concealing evidence, Rule 3.5, which is the rule of professional conduct that would relate to your activities, does not have an intent requirement. It only says you must if you unlawfully obstruct another party's access or unlawfully alter, destroy, conceal a document or material with potential evidentiary value. So the idea, I always tell this to my law students, stop and think. When you have that nagging doubt, there is a reason you have that nagging doubt. Pay attention to it, right? And then the other rule that would govern your conduct as far as production of false information does have a knowledge requirement. It's 3.3. But remember, knowledge can be inferred from the circumstances. So what if you're testifying and it finds out that you knew about that case where Victor Video or from Video Verify was described as a fraud? So you have to be really careful and do some investigation before you proceed in these kind of cases. Think about forensics experts.
Yeah.
When you don't know, hire a forensic expert. They're not even that expensive. They could look at the video and quickly tell you. So you don't trust Victor Verify, hire someone to look at what he's telling you.
Mark?
Technology has never changed faster than it is today, and it'll never change this slowly again. Think about that.
Right.
This has to, you can just turn this right back to competency. This is your job as a lawyer. 1.1, comment 8. You've heard it in probably a million CLEs that you've attended, right, in the last few years. The risks and benefits of technology you must know. That does not say in comment 8, legal technology. It says specifically broad technology. So you have to understand how things work, what's involved in your case, civil, criminal, business technology issues, whatever the case may be. You have to rise to that level and understand it. And if you don't have to know the full details. You don't have to be a coding lawyer, but you also have to recognize, how do I find the experts who do know and connect them to the case? And you're going to see more things like deepfakes. If you don't know what it is, like Wendy said, just Google deepfakes and you'll see some amazing, blow your mind examples out there. And they can be done with your cell phone.
And two more points, and we'll have a question from the audience. So, our group, our jury, our blind jury says 83% seek that continuance to additionally investigate. I would add to that, hire a lawyer. On a serious note, because I think what's going to happen there, what happens when you find out it is a fake, okay? I think you're going to be duty-bound to withdraw from that representation, and you're going to get a hassle from your client about it, right? So you're going to want protection about it. Number one, I don't think I'd ever meet with Carrie alone, by the way. Make sure you got a prover, a witness, when you're having meetings with this client, somebody from the firm. And then free, for those of you who giggled when I said one free bite, but Mr. Mark Haskis and I, when we were young and trying dog bite cases, they used to say you get one free bite, and that's why, is it the first or second time the dog bit the people? All right. All right. There we go. Question up there.
Yeah, what if you're at the courthouse and you tell the client, I'm going to move to continue so I can do an additional investigation. The client asks how much that's going to cost. You say $5,000. The client says, I'm not paying for that.
I think, I mean, if that, I can tell you what Clifford Law would do about that. That's where having a lawyer would be. We'd dot our I's, cross our T's, and we would find a way to handle that ethically, properly, probably withdraw, probably seek, have our counsel go before the court for reasons we cannot explain. We need a continuance. I mean, there are a whole lot of things that you can do to protect yourself, and that's what you would need to do under these circumstances. You cannot go forward with this, and this is going to be a real problem going forward. As Mark was saying a moment ago, technology is so advanced. I mean, go back to the rules of evidence about authentication, okay? When you get a document, what foundation are you going to lay that this document is authentic? Look at photographs nowadays. When I started in the practice, we used to hire photogrammetrists, and we would actually have to get the actual film and look to the edges, because when the defense would produce things to us, they would crop it so that there were things on the edges that we wouldn't see. Now, they could just make it up, and you just got to watch that stuff.
And I'm going to say,
Please enter the following MCLE verification code, 8126.
Basically have to tell the client, like, I need more information.
All right, one more question, and then we have to move on.
Can you hear me? Thank you. Can you hear me okay?
Yes, sir.
The point I thought of, what Mr. Clifford said, was withdraw. I just wanted the judge's perspective. Are you going to allow that withdrawal at the hearing? It's right before trial. And secondly, isn't the client prejudiced? I understand the client is, obviously, it's not to their satisfaction that you're withdrawing. But how do you address that at the moment of the hearing or trial? I mean, it would seem to me you almost have to grant that continuance. But
you can't get into hypotheticals or give advisory opinions. The Supreme Court Rule 13 sets forth how you can withdraw and when the court can grant it or not grant it. So the court would look at Rule 13 for sure to decide whether to grant it. But I don't want to get into
and that's where I say,
do.
And I agree. And that's where I say have a counsel to the firm that's there with you. I mean, that's going to send a clear signal that there's something amiss here. Look, if the court were under those circumstances denied, you got a client saying, I demand that you put forward this video, you've got your problems, you might have to take an appeal from the order denying it. I mean, they're just, you know, that's a very challenging
Yeah,
situation.
no, I agree, and I just wanted to, I wasn't trying to get a specific
Oh, no.
opinion.
I
I was
know.
saying it's a hypothetical answer to a
Okay,
hypothetical.
we have time for one more question. Yes, sir.
We're going to run into a situation where, depending on the wealth of the defendant, they are always going to complain now, bring in an expert and say, the evidence is always fake, and
Right.
then you're put into a bind.
The remark was that given we're going to run into...
Your client can't afford to overcome that expense. I mean, what are you going to do? The rich guy is always going to do this.
Certainly a challenge every day.
Pardon?
It's certainly a challenge every day in terms of the ability of one party versus another to outspend them on litigation. And those are things you have to just take on a case-by-case basis. So, okay, I have to move on. Question number 8. Warren Brennan and Associates, this is email tracking. Warren Brennan and Associates, so happy with its website relaunch and the blog leadership, it explores how it can use email marketing to send its weekly blogs directly to subscribers, keeping clients engaged. It soon adds a tool to its email system that monitors email traffic to issue a report on the blog emails, among all emails, with information such as who opens the email and how long it is read. Now that email tracking is in place for the firm emails, the firm starts to explore what other uses this might have for its work. Question, true or false? Email tracking, especially in conjunction with mandatory e-filing and email service to attorneys, is a vital way attorneys can maintain their technology competency requirement under Illinois Rules of Professional Conduct 1.1. True or false? Okay, Mark?
I can't trick them, Bob. I tried.
No, this is, I think, our first 100%er. False.
I tried really
Oh,
hard
wait,
here.
wait. 30% changed their mind. Wait. Okay, it's a moving target here. Okay. Mark, what do you think?
So this is a very interesting situation, and it's not really new either. And all of you have open tracked emails every single day, whether you know it or not. There's massive companies that do this and make billions of dollars on email tracking. They're not in the legal profession necessarily, but why wouldn't this be a problem for you? Or is it allowed? Well, actually, there have been some ethical opinions across the country that have addressed this very issue. I think they're in your resources out of Alaska, New York, and Pennsylvania. Has joined, in fact, right here in Illinois, too, an ISBA Professional Conduct Advisory Opinion 18-01 from January 2018. And the point it makes is this. We all know what read receipts mean, at least by now, usually in your Outlook, you know, and you get those pop-ups that say, you know, Jane Smith wants to know if you read her email. That's not what we're talking about here. We're talking about spy mail, things that's happening behind the scenes that tells you not only did Jane Smith open the email, but how many times was it opened? How long was it open for? What IP address was it open for? What links within the email did they click? Et cetera, et cetera, et cetera. Why would that be important? How could that be used in litigation, for example? Let me give you a quick example. That's a settlement offer is sent to opposing counsel with tracking put in it. You watch where that email goes and how it's opened. Over the whole work week, you see by the end of the week that email's been opened 11 times for a total of 4.5 hours in 22 different locations, 22 computers, IP addresses, including one way over in Cleveland, Ohio. Well, that's where their insurance carrier is. Huh. You just got all this information anonymously, or at least the opposing counsel has no idea that you did it all without their knowledge or consent. Think that's allowed? Absolutely not. That goes right against the rules of professional conduct. At least that's what all the opinions say, and I would certainly agree with that. And you say, okay, well, I don't see a rule against spy mail in the rules of professional conduct, right? And again, that goes to one of our broader points, I think, of this entire CLE is the rules can apply to modern technologies. The rules can apply to social media, all these things we're talking about. In this case, web bugs or whatever you want to call them, spy mail and things, that constitutes dishonesty and deceitfulness, which is right there in 8.4. 8.4 is the whole big enchilada of misconduct. 8.4c, you can't do that. That's the general quick answer.
I think over 80% of our internet jury here agreed with you. However, for the 20% who didn't, they must have read the new book called The Art of Surveillance Capitalism by Dr. Shohana Zuboff, who I interviewed 2 weeks ago. And you read this book, there's a New York Times, what do they call it, a rewrite of it, and it's stunning what Facebook, Google, through Gmail, the information that they get that is, when they're asking you to sign a privacy policy, it's really a surveillance policy. And the question becomes, does all of the data that you consent to when you exchange that email with me, is that your property or mine because you voluntarily put it out there? And that's what I think 20% of our group has agreed to.
There's actually at least one case out of DuPage County where lawyers were sanctioned for using spyware on their opponent.
There you
Not
go.
a discipline case, but it was a sanction case.
All right, we got time for one question. Yes, sir.
So it seems to me that the lawyers who allowed themselves to be spied on might have violated some duty of confidence.
I'm wondering how they found out. Actually, that was my question.
But maybe they should have had
their
their flags up saying, you know, this is out there, and I better be careful circulating this.
Well, I think to your point, increasingly so. Look, I started my law firm in 1984. I had a computer and a fax machine with that rolled paper. Remember that stuff? I thought it was great. Now we're hiring consultants to make sure that that kind of stuff doesn't happen. You want to be involved in modern day litigation, you have to step up your game on the technological side of the practice. It's just the reality.
There is a niche industry that allows you to subscribe to software that'll tell you if there's spyware within all your email and block it, and either alert you or block you, and it works well from what I've seen demonstrations.
Yeah. Okay, next one, thank you. Client due diligence. You are an associate at ABC Law Firm in Big City, USA. One of ABC's corporate clients, biggest corp, next year we got to have better names here, okay? Wanted to borrow money from a lender for a real estate deal in Ocean City, USA. In order to complete the transaction, the lender wants a letter from the law firm regarding the overall position of the corporation. The lender wants ABC firm to verify in the letter that, 1, there are no lawsuits pending against the corporation. 2, the financial information provided by the corporation is correct. 3, there are no pending investigations regarding the corporation by any governmental or regulatory agency. And 4, ABC Law has conducted proper client due diligence regarding the corporation. True or false? ABC does not have to conduct a client due diligence since the client is a longstanding client who they have represented for many years. Wow. Let me start off. Mark?
Let's see what they say.
All right. Survey says, well, it's still 100%. It's not fully, it's not calibrated yet, unless it's 100% sold that nobody has to.
I think we're going down the right path again.
Yeah, I think we're okay. Mark, what do you think?
I think it's clear. Competency tells you you must be informed. That requires due diligence, right? And that leads to, well, what do you know? In this instance, do you know if something is legit? Do you know if it's illegal? And you can't just close your eyes and stick your head in the sand to avoid that knowledge. Like Wendy said earlier, it has to be knowledge or imparted knowledge on you because you should have known it anyway. You can't just escape it because of that reason. So you go from 1.1 through the due diligence of any transaction, of any representation of you as a lawyer, that's part of your job, into knowing is something possibly illegal that I'm contributing to or helping. But then that's not the end of the evaluation too, because you still under 2.1, you have to give advice, even if it's advice of illegal activities. You're not going to help them with it, but now you better give them their options and say, at least CYA yourself, to say, hey, I recommended they stop this action, they turn themselves in, this is illegal, and now they know it, they maybe didn't know it before, or whatever the case may be.
Wendy?
So the idea, the name of the problem comes from an increased focus on lawyer as the gatekeeper, right? Lawyers having some requirement to do some client due diligence. So while lawyers have no mandatory obligation to report everything they learn about a client, certainly we are considered the gatekeepers of the legal profession and the justice system, and we are in a critical position to encourage our clients to conduct themselves in a manner that's legal, right, and within the guidelines of the law. So you look at Rule 1.2D that says a lawyer shall not assist a client in conduct that's criminal or fraudulent, and that puts on you some obligation to inquire. Here we had a past client, so that is certainly helpful, but still you have the obligation of client due diligence all the time. The idea of client due diligence also includes the concepts that lawyers don't want to unwittingly walk into a money laundering situation or a terrorist financing situation, which has been a big focus of the American Bar Association and federal agencies such as the Financial Action Task Force. And they have a couple of ethics opinions for you, but the gist is that there are certain situations that you should understand, there's a risk here, and ask more questions. Like you get an email, as one of our participants pointed out, referring you a client, and you don't know who it comes for, and you never heard of that client, or the dollar amount that they want to pay you is too good to be true, or they don't want to meet you, and everything's hurry, hurry, rush, rush, right? All of those are risk factors that should get your flags up. The ABA opinion literally calls it red flags. So always do client due diligence. We couldn't even fool you on this one.
We fooled 3% of them.
Yeah.
We're only. But I have a question. But I know. But a question that I had as I was reading this, it just struck me that the law firm is biting off a big responsibility for making these assurances. I hope they are being paid for it. I hope they got insurance for it. I hope they have an indemnity agreement with the client. I hope they've covered their, all their bases. So we had one question there, one question there.
Should a law firm even be giving?
If that's their undertaking, that's fine. Yeah, no. If that's their, I'm sure there are law firms that do that, yeah. but that's their undertaking. They know they're doing it. They're hired to do that. Yeah. Yes, sir.
But can't the law firm deal with this by talking about in the disclosure the limitations of what their examination was, what they looked at, what they relied on, as opposed to making a blanket?
Can the law firm limit its obligations by limiting in its disclosure forms? I think the answer to that is yes.
Mm-hmm.
And then
smart law firm better put that in the opinion letter.
All right, that's right. Yeah, put that in the opinion letter, right? You got one more question up there, and then we'll move on. Okay.
Thank you. Isn't it necessary when giving this letter, as to points 1, 2, and 3, to say to the best of our knowledge? Because it would be impossible for them, even as they sign the letter, to know whether or not there was an investigation going on, perhaps by the FBI, or whether a lawsuit had just been filed 10 minutes before they signed the letter.
I don't think there's any question about that. But I think to the gentleman's question earlier about should a law firm even be doing this, I think that's a question of what is your engagement with this client? Did you sign up for this kind of activity? And I would believe the answer to that is yes. That that's your undertaking, and you've taken steps to protect you and the firm. Okay, moving on, related to this. So same question, but based on the information provided you by the company's CEO and the CFO, you provide that opinion letter on behalf of the corporation. You address and confirm all the bank's questions, and shortly thereafter, the CEO contacts you and advises that the CFO was fired, that the financial information provided you was false, the CEO has been engaged in money laundering and is being investigated by criminal authorities, the CFO. And then later the same day, the CFO comes to you and tells you that the CEO is a liar and fired the CFO because the CFO discovered the CEO was siphoning money from the corporation to his personal accounts. Both the CEO and CFO claim to have supporting documentation. The loan transaction has been approved by the bank, by the lender, but the money has yet to be dispersed. The disbursement is scheduled for early next week. What do you do about the letter you sent to the bank? Nothing, because you cannot tell the bank anything you know about the possibly false information. B, you investigate the information provided by the CEO and CFO, and if it is true, you withdraw the letter to the bank without saying more, and you tell the bank everything you learned from CEO and CFO. Okay, and I'd had 4, do you call your lawyer? Okay, so, Wendy, you're first.
Okay, so this problem falls under the permissive disclosures for financial fraud under 1.6b, 2, and 3, where a client has used your services to commit a fraud. This is the short version of the rule that will cause financial harm to a third party, right? So in Illinois, that exception is permissive, but then you have to look at the rules together, right? So under 4.1 and 1.2d, you may have mandatory obligations to avoid both assisting in a criminal or fraudulent action and to avoid providing materially false information. So what do you do in those situations? First of all, you tread carefully because you'd never reveal privileged information unless there's a crime fraud exception, but you're not the one who decides that, right? But sometimes the rules like 4.1 and 1.2d that are mandatory rules permit you, cause the permissive part of 1.6 to be a requirement, right? So you have to withdraw and maybe disavow the letter that you sent to the bank. It sounds like a big mess, and at least here you want to get out of the case. But you certainly don't want to disclose the privilege information. Oh, the CEO told me this, the CFO told me that, and I agree with Bob. The thing that you want to do first before you do anything is call a lawyer. We should have had D, call a lawyer.
Yeah, really go. Yes, sir.
So who do you talk to in the bank? There's like hundreds of people. Do you talk to the counsel for the bank? Or do you
No, you let your lawyer talk to
You
the
let
bank.
your lawyer. At this point, I
Yeah.
think 100% you let your lawyer talk to the
Mark,
bank.
anything to add?
No.
Talk the bank. Your lawyer will talk to the bank's
bank.
lawyer.
And it's a thing called, you're considering noisy withdrawal to fix this problem.
Noisy withdrawal.
Right.
We have a question from the internet here.
Yes. By the way, a 90%, 91%
Got it right.
said got it right. There you go.
If
Yes.
you're asking a client to ultimately be responsible for the firm's wrongful conduct, isn't that a violation of the rules?
So in other words, if you're asking the client to be responsible for the wrongful conduct of the firm?
That's right, for the firm's wrongful conduct.
Why is the firm engaged in wrongful conduct?
I think this is in relation to the previous question.
So if they go ahead and send the letter anyway, you're asking the client to, to be honest, I don't fully understand the
I'm
question.
not sure I fully understand the question either, but I'm going to go with Bob's answer D, call a lawyer.
Yeah, no, and seriously, apologies to the gentleman or lady who asked that question. We really just don't understand it.
Okay, I'll
Okay. All right, moving along here. Receiving an inadvertently sent email. It's going to happen more and more. In preparation of closing a residential real estate transaction, the seller's attorney, David Green, emails the drafted HUD-1 PTAX and deed for the final review to the buyer's attorney, Christine Lee. That morning, bankruptcy attorney Christine Lee notices an email in her box from David Green with the subject line, 618 East Daniel Street, closing docs. And the email body, my drafts for review. Thanks, DG. Her first reaction, huh? Okay, mine too. All right, select the best response. It's potentially a phishing email trying to get you to open the attachments, delete the email, and move on. She has received an email seemingly relating to another's representation that was inadvertently sent to her, so she must promptly notify David Green. Since she knows the email is not meant for her, she should forward it on to the correct recipient and CC David Green. She should promptly reply to David Green to let him know she received it in error, and then delete the email and attachments and inform the sender of the same. Wow. Okay. Mark, what do you think of this one?
Well, I think everyone's doing a great job on answer D, and I agree with that.
Yeah, our polling jury thus far says 94%, 2-3. Pass it on.
Yeah.
Promptly reply to David.
And that really draws your attention to what's the best answer. It doesn't say what's required under the law, which is very different here. And this is very consistent with the ABA model rule and a lot of the state rules. Your requirement under your ethical obligation is just to notify the sender, and you're done. But is that reasonable? Is that the best solution? I would argue no. And I'll give you a real-life example. I get emails about monthly directed specifically to an attorney by my same last name, Palmer, in Oklahoma. that has a Gmail account. He uses Gmail for his business, which I think is bad to begin with, unless you're using enterprise software. But my point is, every time I get one of these, it can, and it's all over the place. He must be a general practitioner. And I reply back. I have a canned response. I have it so often, and I just copy and paste it every single time. And I say, as this message was sent to me in error, to, and I list the email address, I am giving you notice under such, under Illinois Rules of Professional Conduct, Rule 4.4b, and now delete this original. Please update your contacts accordingly, period. And that's all I send. Every single time, I delete it, I move on, right? Now, if there's an attachments, do I open them? Absolutely not, never. I don't even read what the title of the attachment is, right? Could they be spam? Some of them could be. I never click a link. I never open an attachment. Those are things that are always very dangerous, and that's to point out. But the gist here is you're going to get inadvertently sent emails. Now, the example I just gave was unrelated parties, right? But what about other situations where you're in litigation with somebody and they send you the correct email address to the correct party, but they attach the wrong document? And sometimes it can be a very helpful document to your side of the case, right? Now where things are a little bit different. What do? You still got to follow the ethical rules. And you can expand that example a little further. What about they send you the document, but they've included metadata, as we mentioned earlier, that's in that document that tells you their prior drafts of that document, prior affirmative defenses that they consider and then deleted, for example, all kinds of things like that, prior attachments and so on. So what is your responsibility under the rule? There are some opinions that address these issues, specifically inadvertently sent metadata, use of improperly received information, for example. Specifically, the Florida Bar has great opinions on these issues to check out. The New York City Bar, believe it or not, New York City Bar puts out all kinds of high-tech ethical opinions that are always very informative. Great starting points, and they usually apply, the New York versions, and you kind of backtrack and figure out what rules they're talking about for Illinois. But the gist is, the takeaway for this example, I would say, is reply back, that's your ethical obligation, and then delete it and move on. Unless it's really suspicious and you know it's not meant for you, just delete it and move on like most spam.
Wendy?
So I would just add that the rule that's applicable to this, receiving an inadvertently sent email, is 4.4b, and the comments are very good guidance. So as Mark said, whether or not the privilege is waived is outside the scope of the rules of professional conduct. But comment 2 says if you know the email has been inadvertently sent, you have to notify the sender and allow them to take protective measures. So that's comment 2. But the most important one is comment 3. The decision whether or not to return the information is a matter of professional judgment ordinarily left to the lawyer. And one of my friends, opponents, and he was in his day considered the dean of disciplinary law. He died a couple years ago. George Collins always used to say about inadvertently sent emails, but for the grace of whoever you believe in, there go I, right? So he always used to say his theory on inadvertently sent emails is you send it back. You don't use it. You don't try to argue the waiver of the privilege where it's an isolated instance. Now I see someone shaking his head, and I'm guessing that you're shaking your head because the other balancing factor is, what if you get 10 inadvertently sent emails with multiple attachments? That's a different scenario, right? Under those circumstances, if you know it's inadvertently sent, you might want to notify the sender, and then you might want to consider making an argument that this is such a large production of confidential information that there's a privilege waiver. But it would be my suggestion that you don't use the information before getting a ruling from the judge on the waiver of privilege. So it's a balance between, right, your competent representation, your diligent representation of the client, and then your professional judgment to best represent your client.
Right.
So I agree with Mark. It happened to me at the ARDC with opponents too, in isolated circumstances. somebody would forward me something that was meant for their client, and I always did the same thing. Same answer as Mark. Got this, deleting it, pretend it never happened. When it was an isolated instance, I completely...
Even the one that said that Wendy lady doesn't know what she's talking about. Oops,
right, that one. Actually, I did get one like that.
You know, you mentioned...
They called me a lot of names, too, and I'm like, oh, thanks for this.
Yeah,
now that we know what you really think of me.
You know, you mentioned George Collins, and I think, what a gracious guy he was, and I think one of the things he would have said, it's also a matter of professionalism and civility.
Yes,
that,
100%.
You know, there but for the grace of God, go away. You send it, or you pick up the phone and you call, hey, David, you're sending me stuff that I know it's not for me. I don't even know you. Have a nice day. I'm going to delete it and move on.
Right.
And that's the kind of best practice.
You're an officer of the court as well as representing your client.
And just remember, when those ways, what goes around comes around, and when you're the one that pushed send by accident with something that you didn't want to send to somebody else, you hope somebody would treat you the same way.
There you go. Okay, moving on. Number 11. Lawyers investigating jurors or potential jurors prior to jury selection. Here we go. This is a hot topic. Defendants Emmett, Liam, and Patrick were charged with tax fraud related crimes. Prior to jury selection, the district court, federal court, provided the parties with each potential juror's questionnaire as well as their names and addresses. During voir dire, potential juror Maggie answered no to questions concerning whether she had been arrested or charged with a crime and stated that her highest level of education was a bachelor's degree. During jury selection, Liam's counsel investigated several potential jurors, including Maggie. He learned from a Google search that Maggie was a lawyer who had been suspended from practicing law due to professional misconduct. Liam's counsel also friended Maggie on Facebook and viewed her private Facebook page where she learned that she had an extensive criminal history. Liam's counsel did not disclose this information to the court. Further, the parties in court selected Maggie for the jury. The jury found defendants guilty of all counts. The next day, Maggie sent a letter to the U.S. Attorney's Office congratulating the attorneys on the outstanding job they did representing our government and revealing a deep-seated bias against the defendants. All defendants filed motions seeking new trials due to juror misconduct. Following investigation and eventual hearing, the court determined that Maggie lied extensively during voir dire. True or false? Attorneys are permitted to conduct an investigation into potential jurors before jury selection. Judge, we're going to start with you. This is Judge Clare. What do you have?
So this is kind of an easy question, but it's true, you are allowed to do the investigation. This is based on a real case, which I'll get to in just a second, and truth is stranger than fiction. You could not make up the facts of the real case. Generally, yes, lawyers can research potential jurors and jurors before and during the trial. So a recent issue has come up about Facebook and what can you do in terms of investigating a juror or potential juror on Facebook. I didn't see any Illinois cases on point. I know Mark and Wendy would let me know if there is one. There's an ABA Formal Opinion 466 from 2014 that says you cannot contact jurors, which we all know. However, you can view publicly available information online. So what the ABA says is a passive review of someone's Facebook page is okay, even if that Facebook page or LinkedIn, for example, if you looked at someone's LinkedIn page, LinkedIn will notify the person that this person looked at you. The ABA says that is okay. That is not an ex parte communication. It's just a passive review, and it's the function of the website that sends the notification. It's nothing you did. However, the ABA says you cannot Facebook friend somebody. By doing that, that's an active review. Sending an access request to the communication to the juror that would be prohibited. So under Model Rule 3.5, you can't communicate with the jurors, and sending a friend request would do so. So in this hypothetical, Liam's counsel could not have sent that Facebook friend request. That would have been improper. So in this is a real case out of New Jersey. Again, the facts, I can't even get into what the real facts are, but 5 defendants are charged with a whole variety of several tax-related, fraud-related crimes. One juror, Catherine M. Conrad, she's questioned during jury selection. She answers no to the questions about whether she's ever been arrested or charged with a crime, says her highest level of education is a bachelor's degree. She's selected. 3 months of trial, 41 witnesses, 1,300 exhibits, 9-day deliberation, and the jury comes back with a split verdict. They find the defendants guilty on some crimes and not guilty on others. So she did send a letter. I mean, I didn't make up the facts. This outstanding job for our government revealed she would have found the defendants guilty on everything, and this huge deep-seated bias. So once the U.S. Attorney's Office got the letter, they started doing some investigation into this juror. And they realized she's been arrested and charged with crimes on at least 5 occasions. She's pled guilty to crimes. She was on probation at the time she served as a juror. She's actually a lawyer who had been suspended from practicing law for a whole variety of things and was actually in the process of trying to get her license back. They bring her in for a hearing. They actually have to have the sheriff come get her. And she admits she lied to make herself more marketable as a juror. She admits she made a conscious decision to perjure herself during voir dire. She thinks all defendants and all lawyers are crooks, and she really wanted to serve on this jury. She also said she was been upset that she'd not been able to practice law for such a long time, so she thought serving as a juror would be a fun activity. So the court finds she made a calculated criminal decision to get on the jury, deliberate intentional lies, and grants the defendant's motion for a new trial. One thing, my hypothetical Liam in this scenario, they discover through questioning by the court that Liam's counsel knew a little bit about this at the beginning of the case. They knew that there was a woman named Catherine M. Conrad who was a lawyer suspended in New York, but when she said her highest degree was a bachelor's degree, they thought, oh, she couldn't possibly be lying about that. Didn't look into it any further. During the jury deliberations, Conrad, this juror, sends out a note, and it's not quite clear how they know it's to this juror, but she sends a note saying, are you going to instruct us on vicarious liability? Not a theme that had come up during the trial. So Liam, in my scenario, his lawyer, looks into it a little bit further, finds a little more information that might show that Conrad is lying, does not tell the court. So what the district court does, and if you're a law nerd like me, I'd suggest you read this. It's a really interesting case. The district court is pretty much furious and grants everyone's motions for a new trial except for Liam's, and says that the attorneys waived the issue because they had some inkling that this juror was lying, or at least they had in the exercise of reasonable diligence, should have known. And justice demands that a defendant having reason to suspect juror misconduct not remain silent in order to secure a risk-free trial. So the Second Circuit reversed. It gave Liam, in my scenario, a new trial. It went through very specifically exactly what the lawyers may have known or should have known. But I think the takeaway from all of this is if you do find something out, disclose it to the court. The district court judge in this case said, we could have even, during deliberations, had we realized this was the issue, we could have pulled her out and brought in an alternate juror. They actually did that. One of the jurors had to have emergency surgery. They brought in an alternate on day 2 of the 9-day deliberations. So it's a very interesting situation that luckily I've never seen. But if you do find something out, disclose it so that the court can address it.
There you go. And 96% of our polling jury agrees. So thank you for that, Judge. It's really a hot topic. Jury consultants are everywhere nowadays, and one of the things they do while jury selection is going on, they're looking at social media. Okay, a continuation, lawyer's investigation of jurors during and after trial, number 12. Following a 3-day jury trial, Leo Miller was convicted of unlawful use of a weapon. And after the trial, Miller searched the jurors' Facebook pages. He discovered one juror, Bridget, had posted publicly on her Facebook page about Miller's case during the trial, in violation of the court's order not to discuss the case with anyone else. On the first day of trial, Bridget posted, as if one day of jury duty wasn't enough, SMH, shaking my head, day 2, I'm so over it already. And by the way, this is going, the fact that I got to keep showing up here and missing work just because I'm going to vote guilty, lots of laughs. Bridget's friend responded by posting, vote guilty. Miller filed a motion for a new trial due to juror misconduct. True or false? The juror's comments posted on Facebook during the trial automatically require that the defendant receive a new trial. Judge Clare, you're up again.
Everyone's right with the false. This is also based on a real case.
100% false so far.
Right. Well,
now they check.
now it's changing.
Down to 60. Okay.
So in Illinois, we've got different jury instructions. The ABA Formal Opinion 466 recommends that you instruct jurors explicitly about the prohibition of using social media, and they recommend it early and often. In Illinois, we've got the IPI Civil 1.01, recently amended in May 2019. So now there are 3 separate instructions. 1 prior to opening, 2 during trial, at every break, every lunch break every end of the day, and 3 after closing. So it specifically tells the jurors, don't do any independent investigation. You can't use the internet to search for anything related to the case, the people involved, or the law. Second, you cannot talk to anyone about this case, but it specifically says you cannot post information about the case or your thoughts about it on any social networking sites, and you fill in the blank, Twitter, social media, Facebook, Instagram, anything else. It also instructs jurors why we tell them this. It says, if you do this, your verdict must be based only on the evidence that's presented in court. And if you do this research or you post about it, it would be unfair to the parties. There could be a mistrial, and you can be held in contempt of court. So research has shown that jurors are more likely to follow the admonitions if they're explicitly told what not to do, and if they're told what the consequences are of if they do it. The criminal IPI 101 is a little bit different. It tells the jurors, don't use the internet, don't do research, but it doesn't specifically say don't use social media. The comments encourage judges to remind jurors about it, but it doesn't expressly say it. So this case that this is from is an Illinois appellate court case, People versus Daly. I know the cite's in your materials. It's a criminal case where the jurors were admonished with the 101 criminal one, so didn't specifically tell them don't post on social media. After the trial, the defendant sees on Facebook that the juror had been posting this during the trial. What the trial court did upon a motion is bring in the juror, and they had an evidentiary hearing with the juror. And after questioning the jury, the juror said she wrote them, but she didn't actually mean it, and she didn't mean she's going to vote guilty just because she was there, nor was she influenced in any way by the reply by the friend. The really interesting thing is she said she believes she followed the court's instruction not to discuss the case with anyone else. She didn't think that posting this on Facebook would be discussing the case. And there's a good article that Judge St. Eve wrote in a law review article where lots of jurors think that. They don't realize that posting it is discussing it. And as Mark's talking about how the law on social media is changing, this is something that the people aren't really realizing. So these explicit instructions are helpful. After all this evidentiary hearing, the trial court denied the motion for a new trial, finding that the juror was credible. She didn't believe this. She didn't talk to the other jurors about it. And the appellate court affirmed it, explaining that the trial court had wide discretion, correctly brought in the juror, had a hearing, and the trial court's in the best position to evaluate the credibility of the juror. But the reason why I have this case in here is Justice Walker wrote a dissent saying that this juror was not fair and obviously showed bias, and he would have granted a new trial. And in his dissent, he urges the Illinois Supreme Court to adopt new standards and procedures to better address the problem of juror misconduct involving the internet and social media. And he also urges the IPI to be amended to essentially, I think, include more of the language you see in the civil one, specifically telling jurors you can't post and specifically telling them what the consequences are if they were to do it. So the Supreme Court denied the PLA in this case, but it will be interesting to see if the Supreme Court or the IPI committee makes any changes going forward. And as Mark said, with technology changing and these cases coming up more and more, that may be something that we see.
Wendy?
So I would say it's not that surprising that lay jurors don't understand that posting on Facebook is communicating, because there's a couple discipline cases where lawyers on a jury either blogged or posted something, not Illinois lawyers, I'm happy to say, but from out of state, where a lawyer was on a jury and was blogging about his activities on the jury, and he said in his blog, well, the judge didn't say we couldn't discuss this case, and by the way, she looks kind of like a witch with long spidery fingernails, blah, 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 blah. Right, bad idea. So,
But you know, I think let me kind of take a different perspective here for a minute. I mean, nowadays, go in any Starbucks and just look at all the people there. They all have their heads in their iPhones, and these millennials and Zs and Gen X. I told a judge about an incident recently. I was in the Starbucks, and I'm the 7th person in line, and I'm the only one who uses cash. Last night, I was with a bunch of young people, and I asked each and every one of them if they had a hard line at home, and they don't. So I could see easily a juror sitting there, hey, and I sent you a text, what are you doing today? Oh, I'm on this jury. How's it going? Well, I don't know. And I mean, that's going to happen more and more nowadays. So anyway, our polling jury says 86% false. The true or false, the jurors' comments on Facebook warrant a new trial.
Well, not automatically, but yes, after a hearing.
Right, after a hearing. Okay, continuing with this, post-trial lawyer communication with jurors. After the jury trial concluded and all jurors were discharged, a lawyer from the plaintiff whose client lost at trial contacted a juror to ask what the juror thought of the plaintiff's case and why the jury ruled against his client. The juror, nervous about the lawyer contacting him personally, reached out to the judge to ask whether or not she could or should speak to the lawyer. In Illinois, can a lawyer contact a juror after trial? Answer A, no, unless the court specifically authorizes such communication. B, yes, even if the juror told the lawyer he did not want to communicate. C, yes, as long as communication is not prohibited or involves misrepresentation, coercion, duress, or harassment, and the juror has not made known a desire to communicate, or no, unless the juror initiated the communication. And I will say, just before I ask Judge Clare this answer, there is no consistency in the courthouse about this in courthouses throughout the country, I think. I don't know if there is a best practices. So Judge Clare, how do you handle this, and how should it be handled?
So it looks like we got most people answering C, which would be correct. So in Illinois, we've got Illinois Rule of Professional Conduct 3.5. Specifically says a lawyer shall not communicate with a juror or prospective juror after discharge of the jury if the communication is prohibited by law or court order, the juror has made known to the lawyer a desire not to communicate, or the communication involves misrepresentation, coercion, duress, or harassment. So I had a fellow judge who had this situation happen. What I typically tell jurors at the beginning of the case is you cannot talk to the lawyers, the parties, the witnesses during the trial, not even a hello or good morning, anything like that. Once the case is over, I tell the jurors that that no longer applies. You can talk to the lawyers if you want to, but you don't have to. I have not had a situation where they contact jurors after the court. Right. You know, I've seen the lawyers talk to the jurors in the courtroom, but a colleague did. A juror had emailed the judge saying, a lawyer's reached out to me, am I allowed to talk to him? So my colleague responded with, under these ethical rules, the lawyer may contact you as long as the communication doesn't involve misrepresentation, coercion, duress, or harassment. You have no obligation to talk to the lawyer, and if you don't want to talk to the lawyer, you can tell that to the lawyer, and the lawyer has to respect your desire. So.
Yep. Mark, anything
I think that's the takeaway. The juror is the gatekeeper of that conversation.
Okay. I've actually noticed, though, that there have been lawyers, there's going to be a question over here, Hugh. There are lawyers who will send someone out to talk to the lawyer, to the juror after the trial, and then with an idea of trying to get information that might give them the basis for going in on a motion for change of the verdict, and without disclosing that to the juror. So that's their intent, and that's what they're trying to do. And to me, that even raises, questions about the lawyer's conduct under that circumstance, just separate, standalone, what their intent was. I don't know if you agree with that, but there's a question from Hugh.
Alternate jurors. I don't think we're consistent over in the courthouse on this one. Can you talk to an alternate juror while the jury's out? And I had that come up. And I mean, there was no prohibition in this case against it. Right. Other judges do prohibit it. Yeah. Interesting to hear the panel talk about that.
I would never risk even talking to an alternate until the decision is absolutely finalized.
Well, you know what's interesting about that, Mark, is that, and I think Hugh might agree with this, is that in the state court system, once the jury goes in to deliberate, typically our alternates are discharged. And in the federal system, however, they're not. So to Judge Quish's illustration earlier, where we could have brought in an alternate to start the deliberations over again. So, again, as a practitioner, maybe a good rule of practice is, if you have any doubts about this, you make a motion to the court not to discharge the alternates once deliberations begin, and they aren't discharged until the entire jury is discharged. That might be the best practice there. Okay. Moving on to our next question, number 14, sad sentencing. You represent Danny defendant, ID number 23467. Danny has been convicted of possession of a controlled substance. At the sentencing hearing, Danny tells the judge, Judge Judy, that he has been clean for several months and has been attending NA meetings regularly. The judge takes pity on Danny, who is a first-time offender, and sentences him to the minimum sentence of 6 months instead of a maximum of 3 years. As the sheriffs are coming to get Danny, he whispers in your ear, "I sure fooled her, but what will I do in jail without any drugs?" You leave court and you don't do anything else. You have started you have started a non-password protected blog in order to relieve some of the stress of your job. That night you go home and you post the following: "My client's jailhouse number 2367 sure fooled that Judge Judy. She believed his nonsense about being clean. She didn't even talk to the probation officer. Maybe the fix was in." All right, are you in trouble? Duh. Okay, all right. A, no, your First Amendment rights protect your blog. B, yes, you revealed confidential information in a public blog. Is this from a real case, Wendy?
Yes.
Yes, it is. Here we go. Wendy.
Okay, so I'm glad to hear everyone in the audience laughing. Bad idea. This is an Illinois case from 2010 when blogs were a newer thing. There was a lot of mitigation in the disciplinary proceeding, and the lawyer acknowledged in hindsight that what she had done was wrong on so many levels. She revealed confidential client information in violation of 1.6. She let a lie on a material fact stand to the judge without correcting what her client had told her. And she also blogged recklessly false information about a judge in violation of 8.2. This is not a verbatim fact scenario from the Illinois case, but it is loosely based on an actual Illinois opinion where the lawyer ended up suspended for 90 days.
Judge?
So one other issue I think that this hypothetical looks at is she arguably has violated Rule of Professional Conduct 8.2a. The lawyer shall not make a statement that the lawyer knows to be false or with reckless disregard as to the truth or falsity concerning the qualifications or integrity of the judge or anyone else. So in the real case, she called it Judge Clueless and used some other swear words about a judge. And according to the opinion from the Supreme Court, there's enough detail in there that you could tell, or the people in the community could tell exactly who she's referring to. So,
everyone knew who the judge was, and the problem was she used the real client ID number of her client. So, but like I said, I twisted the facts a little bit. It is a public order from the Supreme Court on a discipline on consent. The lawyer consented to discipline, so it's all there, and Judge Clare told you exactly what she said.
Wendy, you did say one thing, and maybe it was just because you had to skew the facts, but you did say, so now the client says what he says to the lawyer as they're walking out. Why isn't that a privileged communication that would have prevented the lawyer from going forward to tell the judge, "Hey, judge, guess what the client just told me"?
I don't think that the lawyer could have told the judge what the client told her, but you are in a trick bag, and in particular with a criminal defendant, right? You're not going to go up to the judge and say, "Oh, my client told me that he's still doing drugs." But the problem was the way the facts were, and I shortened it as well. The problem was that she let a lie stand in front of the tribunal, and clearly she cannot say, "My client, oh, judge, my client just told me he's doing drugs." But she might have had to withdraw or something under the facts as they stood in the real discipline case. That was the concern. There was a found violation of 3.3a.
So many of these answers today, C should be call your lawyer.
Right, exactly. Call your lawyer.
I think being an ethics counsel might be a boom business going forward. I don't know. Okay, next one. Boosting your client reviews. Hot topic, Google, Facebook, come on. Warren and Brennan and Associates hired a marketing consultant to further boost its branding and outreach to new clients and to retain past clients. Part of the new client journey, a process map, involves a client satisfaction survey at the close of the matter, including a 1 to 5 star review. If they select 4 or 5 stars, it redirects them to complete a Google and Facebook review. If they select 1 to 3 stars, they are redirected to a private response form, keeping the bad review offline. The firm questions the soliciting of client reviews without violating the rules of professional conduct. What advice might you give? True or false? The lawyer may solicit or encourage a favorable review from a client or former client so long as the contents is not fake, false, or misleading. Mark?
Well, it looks like the majority have it here, and I agree with that. Of course, it immediately should trigger some knee-jerk reactions with all of you. Some you may think of, some you may not think of. The one you should come off right away is the 8.4. You obviously can't solicit false information from them or tell them to give a review that does not reflect honesty. That's 8.4C. But first, before we even cross into the bridge of ethics, think about what are the rules with the actual platforms that you're reviewing on. Sometimes they have their own rules. For example, Yelp does not allow you by their own terms of service to solicit reviews. Oh, I didn't think of that. So, yes, there are lawyer reviews on Yelp. But typically, where do we see reviews? We see reviews obviously on Google. We see them on Avvo. Some bar associations are getting into reviews and more platforms. But again, just like we talked about earlier, rule number one, client confidentiality. You got to cross that threshold right from the get-go. Of course, if they're the one leading the review, they're the controller of that information. So that's a tough issue to cross. But what can you not do? What can you not do? You obviously cannot have any type of quid pro quo for the review, but we'll talk about that a little bit more. You can't solicit fake or false information. We mentioned that. And of course, you can't threaten, bully, or harass them. So that leads to a couple things. One is, are there products out there to do this for you? Yes, there are actually. There's niche industries, again, that will immediately send review solicitations to your post clients, your former clients, right after representation. And in that email, for example, it'll have 5 stars, let's say, real nice graphic. They think, Mark Palmer, he was decent, but not the best, 4 stars. They click 4, that'll send them to Google to write a review if they click 4 or 5 stars. But if they click 3 or less, it's not going to take them to Google. It's going to take them to a private form to give you feedback directly and keep you off the website. Is that okay? I don't know. Here's the other problem with that. In order for that third-party service provider to do that service for you, you have to give them your client information.
Right.
Whoops. Is that a violation per se right away? 1.6 comment 2. I wouldn't be very comfortable with doing that. Leads to the last point I'll make about paying for reviews. Well, there's actually opinion out of New York City that says, yes, you can give them monetary payment, or at least maybe a reduction in their fee, in your fee, for a review. I didn't say for a good review. I said for a review. And they're very careful about the language in this opinion, because at first I had the same reaction you probably just did. What? How can we do that? They're very deliberate in their answer. The credit against the lawyer's bill must not be contingent on the content of the rating. The client cannot be coerced or compelled to rate them. They don't have to do it. They don't get the $100 off, though, either. And the ratings and review done by the client, not the lawyer. In other words, the lawyer can't say, here's my template review of how wonderful I am with 5 stars, plug and chug, right? Can't do that either. So, lastly, there's also other considerations. We mentioned the platform rules themselves. There's other things out there like the FTC who are paying attention to sponsored content. You see this all the time on tweets or on blogs. This content's sponsored. That's because when you click that, they earn 25 cents. They get 200,000 clicks. That's big bucks. Okay, same thing here. You are paying them. You're giving them some type of consideration for a return on that consideration. Under FTC rules, I think that needs to be disclosed. That's a whole separate issue. I just want to point that out, too.
Wow. Wendy?
Please enter the following MCLE verification code, 3782.
Software that gears only your good ratings to do a review of you online is deceptive, and the biggest thing you can't do in advertising is do something that's misleading. So if you're like steering only your positive clients through software that your consumers as a whole looking at your website aren't going to know about, to me, I'd be super concerned that that violates 8.4C, which Mark pointed out. And then I would also be concerned, I know it's a New York City ethics opinion, but I'd be worried about paying a client for any kind of review, good, bad, or ugly, and I would talk to a lawyer before I followed that New York City ethics opinion.
There we go. Call your lawyer again. C or D.
Call your lawyer.
Yeah. You know, one thing that we see, so if you search, like if you want to search for certain law firms, one of the things that's happening nowadays is that paid advertisers are bumping ahead of you. So if you search sometimes, like my name or Joe Power's name or some of the others, we don't pop up first, even though that's who you search for, because some paid advertiser is ahead of us. So that's how Google is being manipulated, and it's kind of distressing, but it's what's going on in the legal community right now. Any questions from the floor? Hearing none at the moment. Ma'am? No? Okay. Question number 16. After 4 months of Warren and Brennan and Associates' new marketing plan, it has received over a dozen new online reviews, and its page views have quadrupled. But wait, it just saw that at late last night, a 1-star review was left on its Facebook business page. This former client was clearly more upset about the judge's ruling against him than the quality of representation. At least that's what the partner in the firm thought. I should defend the firm and our quality services, right? True or false? While other industries are more appropriate to response to negative reviews, like hotel reviews, it's an ethical violation to respond or comment on any client feedback in a public forum. Interesting. Wendy?
Well, I guess the way it's phrased on any client feedback, it depends how you respond. Because your big concern here is revelation of confidential client information. And if you call your malpractice carrier, because I've heard them say it over and over again, they'll tell you the only response is A, none, or B, gee, I'm sorry you're upset, call me at my office, which doesn't reveal anything about the attorney-client relationship and just makes you look like Joe Nice Lawyer or Jane Nice Lawyer or whoever you are, Nice Lawyer, right? And there's something called the Barbra Streisand effect. Does anyone know what it is?
No.
Okay, so the Barbra Streisand effect is by trying to make a big deal about something, you can create more attention. A photographer took pictures of her house on a cliff in Malibu. She's a very private person. She was so mad that the photographer took these pictures of her house and posted them on the internet that she sued him. Before her lawsuit, 3 people had looked at the picture, her lawyer, and the photographer. After she sued him, hundreds of people saw the picture of her house on the internet. So the idea is, client posts a bad review about you on the internet, on one of those lawyer review ads, ignore it, or just say, gee, sorry you're upset, call me at my office.
Well, and that's,
B, call your lawyer.
Yeah, call your lawyer. Mark?
Yeah, well, obviously, like Wendy said, the ethical rules come first, and confidentiality is top of those rules. But also, you got to consider, was this review meant for me? Was this a mistake, just like the mistake in emails? Were they thinking of a different person when they did this? And if so, was this person even your client to begin with? And that does happen. You get bad reviews on the wrong website, and like, oh shoot, what do I do now? Now you have to turn to the terms of service for that platform, whatever it may be, and they all are different in how you correct this problem. LinkedIn does it differently than Avvo does it differently.
Well, there are certainly services nowadays that you can hire that will work with you to drill down about bad reviews and see what you can do maybe to get them withdrawn. Because, again, this is probably happening more in general commerce than in the profession, competitors are filing bad reviews of their competitors and again, boosting that they're manipulating Google. I think I saw a question up here, is that right?
I believe, and I'm willing to be corrected on this, that in addition to not giving out confidential information, you cannot in your comment impugn the client or insult the client. Provide negative information about the client.
Yes, and I neglected to say
like
there are...
like he's a wacko? We can't
right.
say he's a wacko?
Right.
All right.
Agree, and there are discipline cases from all over the country where lawyers responded improperly to client reviews. There's some from Illinois, there's some from many states, and some of the sanctions are a suspension, period of suspension.
Well, our polling jury, by the way, they've done a great job today. Our polling jury, 81%.
They've been amazing.
They've been amazing. They've gotten it right. There's a lot of ethical lawyers out there who are doing it well.
I have one comment here from the internet.
Yeah,
And that is that in regards earlier to when you were talking about limited scope representation, the ISBA publishes a consumer legal guide and called A New Way to Get Legal Help on Limited Scope Representation. So I think, as you had mentioned, Mark Palmer, the ISBA can provide a lot of resources for people on whether it's consumers or legal help on many of these questions.
All right, before Pam closes, I want to take this opportunity to thank our three panelists. They've been wonderful, and
thanks to the jury.
The amount of time and energy and effort they make in preparation for this is really remarkable, and I am very grateful. Can't thank you enough for doing it.
Thank you.
For everyone on the internet who's listened in to this today, thank you for doing so. And for all of you here in the audience, thank you again. Pam, you formally have to close the program.
Yes, thank you for attending today's program, Ethics 2020, The Future is Now. In regards to your CLE certificates of attendance, there's now a new format for providers reporting CLE credit earned by Illinois licensed attorneys. Therefore, CLE certificates will now be generated upon Clifford Law Offices' submission of each attorney's attendance to the MCLE board. So please be sure that you give us your ARDC number in order for you, and expect the certificates to be delivered via email approximately 2 weeks after today's viewing. So again, also, would you please take a moment to fill out the evaluation form and return it. It's either at your desk or you can do so online at the evaluation tab. And from all of us at Clifford Law Offices, we'd like to thank you for attending, and we hope to see you again next year. Thank you again.